My name is Campbell Dumont, and the case I chose was First National Bank of Boston v. Bellotti, 435 U.S. 765, and it was decided in 1978. Background. The General Laws of Massachusetts, Chapter 55, Section 8, made it a crime for any banking or business corporation to make contributions or expenditures for the purpose of influencing the vote on any question submitted to the voters. And this is in bold just to highlight that this statute referred specifically to referenda or referendum questions. It doesn't speak about general elections or any sort of race where there's political candidates involved. However, even this statute has an exception. The exception is questions materially affecting the business or corporation. Now, in 1976, a constitutional amendment was proposed, authorizing a graduated personal income tax. The First National Bank of Boston and 4 other corporations wanted to spend their funds to publicize their opposition to the proposal. Francis X. Bellotti, the Attorney General of Massachusetts at the time, made it clear that he intended to enforce the ban on corporate advocacy. In this case, he is the state actor. In response, First National Bank of Boston filed suit claiming that the statute violated the First Amendment. The Massachusetts Supreme Court upheld the legality of the statute. It was appealed to the Supreme Court. Arguments for both sides. The First National Bank of Boston advances that corporations have First Amendment rights. The expression in question concerns basic economic and political policies that a corporation has a right to discuss and the public has a right to hear. The government does not have a compelling interest and the ban is not the least restrictive means possible. Bellotti, in response, is going to say that corporations don't have First Amendment rights. They're artificial creations and the government does have compelling state interests. It actually has 2 compelling state interests. The first is to prevent corruption or the appearance of corruption in elections. And the second is to protect shareholders. And this idea was a little foreign to me, but the idea is that shareholders are homogeneous when it comes to economics in a corporation. They have fiscal goals, and that's why they invest in the corporation. However, the shareholders do not have social or political, socially and politically, the shareholders are heterogeneous. They do not agree in if they were forced to funnel money towards political and social positions that they disagree with, that's a violation, and the state of Massachusetts has an interest in protecting the interests and the rights of these shareholders. The legal question, this is actually very interesting because the lower courts and, as you saw, the appellee and the appellant both frame the question as whether and to what extent corporations have First Amendment rights. Both of the arguments were based on whether corporations do or whether corporations don't. Now, once this goes to the Supreme Court, Justice Lewis F. Powell Jr., who is going to write the majority opinion, reframes the case. He says that the question instead should be whether Section 8 abridges expression that the First Amendment was meant to protect. So here we have a major shift from the who and the source of the speech to the what or the speech itself, and if the speech itself warrants protection. In a 5-4 decision, the court ruled that the statute was unconstitutional. The majority opinion reasoned as followed. The speech in this case, freedom to discuss politics, is integral to the First Amendment and thus protected. The speech itself has an inherent value regardless of the source for informing the public. Powell is also going to introduce a bit of a slippery slope argument, and it has to do with the term materially affecting. So if a government can decide what's materially affecting a business, if they can say, Corporation A, you can speak on X, Y, and Z, then what's to stop this from affecting all corporations? Because in this case, the First National Bank of Boston is a for-profit corporation. But what's to stop the government from telling, say, civic corporations or religious corporations what they can and they cannot speak in? The government has not proven that the corporation would have an overwhelming or significant impact on voters. Further, shareholders are protected. And he's going to advance, Powell, that shareholders are protected because there's an internal structure in these corporations, which he refers to as a corporate democracy, in which the shareholders input what positions the corporation supports. Further, he's going to point to the over-inclusiveness and the under-inclusiveness of the statute itself. So the statute is over-inclusive in the sense of it does not consider a situation in which the shareholders unanimously agree to support a political or even a social position. However, the statute is not only over-inclusive, it's also under-inclusive because it does not refer to general elections or any type of candidatal races. It only refers to referenda or referendum questions. So the important thing to note about these findings is it's very narrow. Powell had much give and take with the other justices in order to swing them to the side of majority. That's why I personally think he shifted from the rights, the First Amendment rights given to corporations and focused on the speech itself. I think that made the case and reversing the situation of Massachusetts Supreme Court much more palatable to the other justices. There was a concurring opinion filed by Chief Justice Burger, and it reasoned as followed. The statute risks harming the speech of organizations who operate as corporations to ensure mass communication with the public. The statute has a good chance of violating the First Amendment because many news sources are part of large media conglomerates, which would fall under this corporation umbrella that the state is advancing that they have a right to regulate. There are two dissents in this case. The first is by Justice White, joined by Justice Brennan and Marshall. And he begins his dissent by saying that the principal function of the First Amendment is to protect communication that serves as a means of self-expression, self-realization, and self-fulfillment. Profit-making corporations, their speech do not advance these means of self-expression, self-realization, and self-fulfillment. He's also going to go back to the shareholder issue and say that this corporate democracy proposed by Powell, it's not enough to protect shareholders and to protect their heterogeneous beliefs. He will also reiterate that corporations are artificial entities, and also that the state does have a significant interest, which has been settled in law, to prevent corruption and the appearance of corruption and to maintain a fair electoral process and a fair democracy. And he's going to state that there's heightened danger when it comes to corporations because corporations are endowed with special privileges such as limited liability that gives them vast economic power. So if they're allowed to use these economic powers in terms of political decisions and elections, then they could greatly influence democracy. Thus, they need to be regulated. Justice Rehnquist files his own dissent, and he does not buy into Powell's reframing of shifting from the who to the what of speech. He's going to say that corporations do not have First Amendment protections, and that is simply the question in this case. He's going to say that the Supreme Court has not ruled on whether corporations do have First Amendment protections. However, the court and the legislature of Massachusetts did reach a consensus that this is unconstitutional and that the consensus between two different branches of government should be considered. Further, corporations are artificial beings created by the Commonwealth for a limited purpose. They are regulated by government and do not enjoy the same rights of natural persons. And the fact that they do not enjoy the same rights of natural persons is not a new concept to the court. In United States v. White, 1971, the court ruled that a corporation does not have a right against self-incrimination. The significance of this case. A few years later, Austin v. Michigan Chamber of Commerce comes up. In this, they cite Beloit for saying that political speech does not lose First Amendment protection due to the speaker being a corporation. However, there is a caveat. If there is a compelling state interest, which they assert there's a compelling state interest to protect against corruption or the appearance of corruption, which allows states to regulate corporations and their contributions. Now, an important thing to note about Austin v. Michigan Chamber of Commerce is all the justices except Powell, who had retired at this time, voted with the majority. So they did not think that allowing the states to regulate these corporations defied Beloit. The courts ruled in similar cases according to this precedent, such as in McConnell v. Federal Election Commission of 2003. However, things start to change once we hit 2010 and Citizens United v. Federal Election Commission is decided. So Beloit is cited in the majority opinion of Citizens United 24 times. It is heavily relied on. In this case, overruled the central ruling in Austin and McConnell, asserting that corporate funding of independent political broadcasts in candidate elections cannot be limited by the state or regulated. Now, I do have qualms with this, but my qualms are less with the way Beloit was decided. I just think it's important to note that Beloit was decided very narrowly, and in the Beloit opinion, it says that referenda are held on issues, not candidates for public office. The risk of corruption perceived in cases involving candidate elections simply is not present in a popular vote on a public issue. Beloit also says that we find no support in the First or 14th Amendment or in the decision of this court for the proposition that speech that otherwise would be within the protection of the First Amendment loses that protection simply because it's a corporation that cannot prove to the satisfaction of a court a material effect on its business or property. So although I do understand that Beloit does say that you can't just limit speech because it is being spoken by a corporation in regards to politics, I do think that Beloit heightens the chance, recognizes the heightened chance of corruption in different political arenas, such as candidates running for public office. And because of this, I do not think Beloit is good precedent for the decision in Citizens United. However, I will acknowledge that I think it's the only precedent that could be used in Citizens United because it seems to be a break from the pattern that the court was in. Okay, thanks. Sorry. And